18. Yes, 18. Well, item 16, I may need some time, my lord, to prepare it. For a week, my lord.
Item number 16, sir.
16.
Well, there was no request for adjournment circulated, Mr. Roy.
Well, just only in the evening, we will receive my list only at night. And I am newly engaged.
Okay, Mr. Roy, Senior Counsel Mr. Roy submits that he has been engaged to appear on behalf of the appellant in this writ appeal and needs some time to prepare and argue the case. List up 4 weeks as spread.
Available.
Forest land allotment case. Forest allotment and reserve forest. Yes,
Lordship, with the consent of the opposite party, beg to mention item number 23 or
23.
23. Appellant needs some time to bring some documents on record, Your Lordship. 10 days time may be granted.
And Counsel, Mr. Your good name, please.
RP Hazarika.
Arthur Zarika representing the appellant submits that some more documents are required to be brought on record on behalf of the appellant and thus, 10 days time may be granted
10
for doing the needful.
Deeply applied.
The other side is no objection. List after summer vacation.
May I please, your lordship? I beg to mention item 33 of the daily list, your lordship.
33.
Yes, lordship.
Yes.
We have circulated adjournment petition.
Why do you want an adjournment? This is a PIL.
Yes, lordship, we need to file our rejoinder affidavit.
Counsel for the appellant petitioner praised for and is granted 6 weeks to time to place the rejoinder affidavit on behalf of the petitioners list after 6 weeks.
Deeply obliged. Thank you.
Lordship, in item number 40, your lordship, yesterday we have filed an affidavit, lordship, that may be called for lordship. Much
Call the
obliged.
May I please, your lordship? With the consent of other side, I beg to mention for item number 43, lordship. Let the matter may come after vacation, lordship.
What is it, Ms. Kale?
Lordship, appeal filed by yes.
That we know.
Lordship, they said their counsel from Calcutta is some difficulty.
And Gauhati has got such good counsel. Why do you need people from Kolkata?
Lordship, that.
Do you feel that there is any question about competence of Gauhati Council? We find them to very good. All right. This can't be a ground for adjournment. You don't threaten us with presence of counsel from Calcutta or Delhi. We are not bothered. Okay. And counsel for the respondent prays for time. Ms. KL has no objection. List up 6 weeks.
Only date may be fixed, lordship.
Absolutely no.
Madam, one pending matter, madam, regarding reducing of grade pay, madam, of research, madam. That has been already lots of hard in some other occasion, madam. Matter may come before vacation, madam. Any date subject
You want a listing?
for listing, madam.
When was it heard?
It was hard on 3/5/23. Last.
So what is the next date fixed? We don't know.
The next date is not given. That was not given.
It's a hearing category matter.
Yes, madam. It was in the admission problem.
May I please, lordship? Lordship, I beg to mention for listing the matter, lordship. Lordship, this matter is supposed to be listed on 14/6, lordship. This lordship interim order is against me, lordship.
It was a fixed date.
A fixed date, lordship.
Why it has not been listed? Find out. And if so, get it listed tomorrow
Lordship
on Monday.
on 19, lordship.
Yeah, 19th.
Grateful, lordship.
May I please, your lordship, I beg to mention a writ appeal fresh filing matter, lordship, which was filed on 13 May, lordship. The matter was not listed, lordship. Kindly matter may be taken Monday or
There must be some defect. Otherwise,
already numbered, lordship.
already numbered. Get it listed on Monday. Very well. But they have got the digital report. They downloaded it from the original file could not be
Yes, lordship.
pressed out. But luckily, the record was digitized.
Yes, lordship.
So we can go get a photocopy made from the digitized records.
Lordship.
The office has reported that despite all efforts, the original record of writ appeal number 172/2011 could not be traced out. However, the note of the registry also indicates that the original record of the said rate appeal was digitized, had been digitized. In this background, comma, the registry is directed to download the record from the digitized files and prepare an additional set of the rate appeal, which shall be tagged with the present proceedings. List after summer vacation.
Item number 2.
May I please, Your Lordship? Lordship, in terms of the lower Jama court proceeding dated 8/2/2022, this matter may come up on admission, Lordship. As it is reflected that, Lordship, the notice has been delivered to the addressee itself on 23/12/2021, Lordship. Lower Jama court proceeding dated 8/2/2022.
But thereafter, there is a direction of this court on 5/8/22 that notice is not served and a fresh notice has been issued. So that procedure has to be undertaken.
And dusty service was directed to be taken. Dusty.
Get a fresh notice is served on the respondent. Actually, this is an error. Just because before that, the office report is that the notice is government. Since there is already an order of report. All right. In view of the order dated 5/8/2022, comma, counsel for the appellant is required to take fresh steps upon the respondent by the STI process. The direction has already been given on 25/1/2023, counsel for the appellant to comply within 7 days. Fresh notice be issued to the respondent number 7. Thus, the service is permitted.
Item number 3.
Ah, that's right, that's right. There's no one. Yeah, repeated allegations. That had gone through. There was a suit also. Then they're not served the respondents. The counsel for the appellant is granted last opportunity to file affidavit in support of the STI service on the unserved respondents. If needful is not done by 28 June, comma, the instant IA and the connected writ appeal shall stand rejected without, for want of prosecution, without further reference to the court.
Item number 4.
This is a matter relating to provincialization of service.
Actually, on the last occasion, it was fixed for seeking further instruction.
Yes.
But unfortunately, Lordship, the appellant is suffering from some ailments. We have not been able to get in touch with him, Lordship. Should we kindly allow some more time to get updated instruction?
And counsel for the appellant pays for and is granted further opportunity of 4 weeks to seek instructions from the appellant.
Obliged.
List of 4 weeks.
Item number 5 and 6.
May I please, Your
Focus would be there because basically it's the appellant who has distributed the compensation. We last take the question regarding the cause of action. Yes,
My lord had raised the issue regarding.
Ms. Kalita, what do you say on condonation of delay?
Condonation of delay, Lordship, I don't have much issues, but like as far as Lordship, this, they filed another IA for making Union of India as appellant.
Okay.
But this IA has been filed by EPL only, Lordship. So from the side of Union government, there is no consent or nothing has been put on the record. So whether that is possible, Lordship.
That IA is not there before us.
It's item 6, my lord.
The government has only been, they used it for some other. That is, they are. For this purpose, they are the real part. So they have contested. Yes. Heard on the application for Mr. Fukan point draws the court's attention to paragraph so and so of the impugned judgment and urges that the direction to bear the brunt of the award and the interest, etc., has been given up upon the appellant, and thus, the appellant is the person aggrieved, party aggrieved in this litigation. In view of the submission so made, the appellant is considered to be the aggrieved person, aggrieved party in the proceedings. The matter comes up for orders on IA number so and so, seeking condonation of delay of 54 days occasion in filing of the connected writ appeal. The state government, the state of Mizoram, response numbers 1, 2, and 3 are represented by Mr. A. Kalita. Response number 4.
Lordship, I'm appearing for 4, P. for Gary on behalf of Mr. S.K. Mehdi.
MS so and so, associate to Mr. S.K. Mehdi, Central Government Council appears for the response number 4. No one appears for the private respondents for whom service has been effected by publication in newspapers. Having heard and considered the submissions advanced by Mr. Fukan and the learned counsel representing the respondents, and after going through the contents of the application, we find the reasons mentioned therein for explaining the delay to be germane. Hence, the prayer for condonation is accepted. Delay is condoned. The official register the connected appeal and list the same for admission.
Subject to convenience, may I request for a specific date?
In the next week,
25th or 26th, my lord?
25th. Again, you will have to take the exercise of serving them in the appeal. That exercise will again have to be repeated.
I'll try to inform the council also,
Let's see.
who had appeared before the learned single judge. I'll try to apprise him also, my lord.
Can try.
Deeply obliged.
Item number 7.
Have your lordship. Lordship, notice was issued. Lordship, I have taken steps. I'm appearing on behalf of the respondents.
Both respondents,
Yes,
what do you say about compliance?
My lord, I have received instruction, my lord, and already the officials, my lord, who was as per the report, we have initiated proceedings against them, my lord.
All right,
That was the
counsel.
direction, my lord.
Mr. So puts in appearance on behalf of both the respondents. If prays for and is granted 4 weeks time to place
My lord,
the compliance report.
my lord, obliged. Highly obliged, my lord.
Item number 8.
May I please your lordship?
Yes, madam.
Respondent number 1 to 14 has entered appearance.
15 and 16.
15 is as per my learned friend saying 15 is died, lordship.
You are 15 has passed away. So you need to bring on record the LRs. And about 16
16 to official respondent, lordship.
is official.
Yes.
Let's see.
Regional Labor Commissioner.
Hmm?
Regional Labor Commission.
Okay. The pro forma respondent, basically.
Yes.
Respondents numbers 1 to 14 have been duly served and are represented. Learned counsel Shri
M.K. Sharma.
M.K. Sharma appearing for these respondents is informed that the respondent number 15 has passed away. Thus, learned government counsel to take steps for bringing errors of such respondent on record, if so desired. Respondent number 16 is a pro forma party, thus service need not be effected on such respondent. Current counsel MS Bora prays for and is granted 4 weeks time to take steps pursuant to death of the respondent number 15.
Item number 9.
The eyes have filed for the delay of the condemnation of 1199.
Only.
Only lordship. So it is coming for the first time. So matter.
So what?
So
What of that? First time means what? It is your first appearance or it is the first time listing of the petition?
Is the first time listing.
Delay has to be explained today only.
That's why.
Otherwise, there is no second chance.
That is. So may I pay, let them, if lordship may notice to be. issued.
What for? Satisfy us that it is a case for issuing notice on your application, please.
So some facts has been, could not be considered by the honorable single judge.
Could
And-
not be considered.
Yes.
For that a review lies.
Regularly, because the department have seeking 13 post of advertisement post and the APSC has only 3 posts.
Mr. Counsel, we have read your application. There is no mention when you have come to learn about the judgment.
Nothing.
It is after retirement, let's say on
Understood, you have retired on 29/2/2020.
20.
Then where is the mention? You only engage, you only say thereafter that in the month of April 2023, you have engaged a new set of counsels. Isn't it?
There is nothing in merits.
April 22.
Right. Okay.
Because-
Right.
I'm not in a position to, I'm for the retired person, then.
What of that, sir?
after
That's misplaced sympathy. Retired person is
there
not
is some
supposed to know about his rights and liabilities.
There's some communication gap on this regard.
Oh,
Yeah.
where is your notice to the lawyer that you didn't inform me? Did you give a notice to the lawyer that you didn't inform me about the disposal of the petition?
That is.
That is not,
so
then,
it is-
sorry, sir.
okay.
I get dismissed.
Public.
And 2 lines on merits also. Yes.
Item number 10.
Right of the permit news, it's a fresh appointment, so there is no question of counting earlier service.
Please, Lordship.
Compassionate appointment
Yes,
after
Lordship.
24 years. Why shouldn't we dismiss it with cost? Tell us.
Lordship, delay was due to medical.
Oh, gentlemen,
We have a next Lordship certificate also.
certificate, let us see the certificate. Where is the certificate?
Lordship in the IA page number 9.
Oh, this is for the IA. We
Yes.
are asking you for your original cause.
Lordship.
You came up in this court after 24 years, sir.
That is covered.
There's nothing good. Claim can't be entertained after such a long period. Sorry. Very well, you do that. All right.
Lordship,
We'll condone the delay and dismiss your appeal on merits.
Lordship, conducting counsel in this matter, Mr. Priya, kindly may allow. one
Pass
day-
over. Let call him.
Oblige, Lordship.
What we do is we'll just direct and the appeal will be numbered.
Item number 11.
The appeal has been numbered. Whether these procedural things are very. They have to be kept. There's a big law in the proceeding which is taking place here. We allow corrections in the cost and the execution by that. How does it get to change? Your point. Yes.
No, this is IFO coordination of delay, my lord, notice would go.
What happened in the other two matters?
My lord, in one of the matters, notice has been issued, Dusty is service is complete.
You notice of the interlock the application number so and so to the respondent. Steps, respondent, steps for service, there are 4 respondents.
Okay.
Steps for service be taken in 7 days, whereafter process be issued. Dusty service is permitted. Rule is made returnable in 4 weeks.
Okay.
Item number 12.
There's the unauthorized possession and occupation of the land of institution.
Procedure. That order will come. Now we have a procedure of PLPC. Madam, you have got the notification? PLPC. Notification.
Yes.
Jackie, Dena.
Lordship, I have subsequent.
We have the.
Yes, that matter, but the notification has been. You have got a copy of the notification?
Yes, Your Lordship.
Yes.
This is for item number 19 I have.
The notification is a general direction. All right, you go and make a complaint to the PLPC. Read the order. Yeah. The petitioner has approved this code by way of this writ petition. In the nature of PIL, styling it to be a PIL, seeking the following relief. Allegation thus set out in the writ petition is regarding, this is a government institution.
Yes.
Encroachment on a government-owned school. Government-owned?
Yes.
Are you sure?
Yes, this is
Government-owned school?
Public high school. Public high school.
Public high school?
But the land is Rayati landlordship.
Whatever, let him file a complaint.
Yeah.
We feel that the issues sought to be agitated through this writ petition involves significant disputes of facts, and thus, the petitioners are required to approach the PLPC constituted in terms of constituted for the district concerned in terms of the Government of Assam notification number so and so dated 24th May 2023. The petitioners may file a representation to the competent authority for ventilating the grievances set out in this writ petition along with a copy of this order. Upon receiving such representation, the PLPC concerned shall objectively consider the same, and after providing opportunity of hearing to the parties concerned, shall take appropriate steps as per law. Within 6 months from the presentation of such representation. Needless to say that in case any adverse order is passed, the petitioners will be at liberty to take recourse of the suitable legal remedy for ventilating the same. The instant PIL is disposed of with the above observations and directions. This will take care.
Obliged.
Item number 13.
This committee was as a matter of fact constituted
May I please?
pursuant to directions given in that case. Yes.
Lordship, in this matter, Lord Additional Advocate Mr. K. Kaur was about to appear, my lord. Because of his medical emergency of his mother-in-law, my lord. He rushed to the hospital, my lord. We need some.
I understand, but this writ petition has been allowed.
My lord.
Why you are in appeal?
My lord, there are some law points are there, my lord. We will satisfy, lordship. Some accommodation, my lord.
Achha, this is the state. Also.
State,
Okay,
my
okay.
lord.
Provincialization, yes. That is a special bench we have formed. This is a matter relating to provincialization or what?
No, pension, my lord.
Not
Calculation of pension.
All right.
New pension or pension.
The state council, Mr. Sohn submits that arguing counsel, Mr. K. Kumar, has been held back in some personal emergency. He prays for time. List after 2 weeks.
My lord.
Please start summer vacation.
my lord.
Can
I
we
thought
fix
that
a
this
date,
is
my lord? Cannot, can be a date.
19 July. This one 19
Kindly oblige your lordship.
Oblige. For item 14 and 15 also same prayer, my lord. We are for the pay and arrear department, my lord.
Hmm. Okay. It is submitted that arguing comment council, Mr. K. Kumar, is held back because of some personal difficulty. And a request is made to adjourn the matters. What do you say?
Well, may pay for a fixed date, my lord.
In July? What is the urgency?
My lord, they are terminated, my lord, in my lord. From service, my lord.
When? Long back?
Yes,
Hmm?
18, my lord. So then,
There's no, heavens are not falling right now. Re-notify on 28th July.
Highly oblige. my lord.
oblige me.
Highly oblige.
Item 17.
Yes.
Question before Mother against not granting interim order. Question before the learned single judge was, they got license under the dealership rules for dealing in business of limestone. They
Hmm.
purchase limestones from Meghalaya, they might not crush it, then they sell it. So these licenses, your lordship will kindly see the rule. Rule is at page 70. This is the rule. It is given by the Mines and Mineral Department of the Government of Assam, Geological Mining Manor. Page 71. C, my lord, competent officer is gazetted officer authorized by the Deputy Commissioner.
Mr. Das, you are against an order rejecting your interim prayer.
Interim.
Why don't you request the learned single bench to decide your writ petition?
My lord, it will be, my lord, this dealership license is up to 31/3/24. It is very difficult to get, my lord, dealership license.
Hmm.
They, my lord, in another case, Learned Single has directed that you consider giving license under the dealership act. Your lordship will kindly see. So I think committed mistake. And the Learned Single refused to grant only on the ground that my lord, limestone is a forest road. How does it relate, my lord? The dealership license, my lord, your lordship will kindly see page 70, and the licenses given by the authorities at page 25. What will I do with the license if I cannot operate? My lord? It is very difficult to get license. In similar case, my lord, the court directed the authorities to grant license. And after granting license, my lord, DFO, my lord, the forest official doesn't have any power to say that you cannot crush, my lord, limestones in the stone crusher. Stone crusher belongs to me. The land belongs to me. And the license.
You are importing the lime from Meghalaya.
But I do not buy from the my lord, state of thing. Well, and my lord, 22, 23 license, my lord, I could not operate because of the, my lord, your lordship will kindly say to first order issued by the my lord, no, forest official at page 23.
23.
23. This is a letter to everybody. Then I'll just read first paragraph, my lord. With the subject cited above, I like to inform you that all of you were earlier requested not to use limestone in crusher units being Schedule 10 materials which are under the purview of the Director of Geology and Mining Assam. And whereas stone crusher units have been permitted for installations by the permit committee, so and so different. So lastly, my lord, it says you go and obtain license from the competent authority. Then thereafter, your lordship will kindly say that page 99. Page 99, by an amendment, my lord, government has withdrawn that limestone from the mineral rules. Page 99, your lordship will kindly see.
Okay.
This is, my lord, page 99. This is a notification on the 3rd March 22. And my lord, your lordship will see the principal rules in the list of minor minerals, serial number 10. Serial number 10 is limestone. And the authority which, and the principal rules in schedule 10, serial number 7, and the entries relating thereto shall be omitted. That means the limestone has been omitted from the minor mineral rules. And now your lordship will kindly see the license given to me, page 25. These licenses are very difficult to get, my lord, tedious process. We have to give so many documents, and ultimately they got.
Is your crusher located in a forest area?
No, no, no. It is on my own land, my lord. And earlier I used to crush stones.
Now stones have been cancelled and I'm not interested in business of stone. Now I'm buying stone from the state of Meghalaya, I'm crushing it and mostly selling in the state of Tripura and Nagaland. Mala. And also sometimes government contractors also buy from me. And now the notification your lordship will see the impute notification page 100, my lord. One by one, without any authority of law. My lord, whereas as per Schedule 10 of the Assam Minor Minerals rules, any grade are listed for industrial use. This is not. This limestone is taken away by 22 notification.
What do you say? What business does the forest authority have to
My lord,
regulate the operation of a crusher?
we are not preventing them from crushing. You crush it in your own crusher, but forest crushers, my lord, it is meant for stone crushing, my lord. Yeah,
Forest crushers means what?
Stone crushers are, my lord, regulated by the forest department, and limestone is not a forest produce. So we
Yes.
say limestone being a,
Stone crusher installed even in a area which is not a forest.
that there is a rule, my lord, under the rule.
Let us see the rule.
No,
Let us see the rule. Who grants permission to the stone crushers? They have their license. Let us see.
It is stone crusher, my lord, not lime. In the stone crusher,
Yes.
I can crush
Who has granted
lime,
the-
also stone, my lord.
Oh, gentlemen, who has granted the permission, Ms. Das?
My
Where
lord,
is your permit?
there is a
Permit is,
PI
my
file.
Just
lord,
hold on,
your
please.
permit has 25.
Oh, so who has granted it?
By the Geology and Mining Department as per rules. Forest Department doesn't have any rules to control for limestones, man. In any
No, irrespective. He says that stone crusher license
stone
is,
crusher license, man, that stone crusher license is a different thing. But here I have got license to process.
we
fine
want to know,
limestone.
we want to know under what provision of law does the forest have the power to grant permits for the stone crushers?
Now, stone crusher is a, well, that your lordship will have. Doesn't? This is Assam Stone Crusher Establishment and Regulation Rules. This
Who is the
stone
competent
crusher.
authority?
Yes, sir. The stone crusher is competent authorities, forest officials, but this is stone crusher.
Let us just please.
Well, I'm sorry, my lord, I got only one to speak myself.
Either the stones or the speaking. The mining engineer. Let's see. Air Pollution Control Act.
Yeah, that
Yes.
pollution certificate we have up to 26, 27. But this is stone crusher. In my own stone crusher, I can crush limestone, my lord. with the
Stone
permission.
crusher shall be allowed only on such land which is certified as non-agricultural land by concerned circle officer.
This is stone crusher, my lord, nothing to do with limestone.
Just hold on. There seems to be some kind of anomaly in the law. What forest department has got to do with the stone crushers?
Well, stone crusher, stone is a forest produce. Stone
Oh,
is also a minor mineral.
If it is sourced from different sources also,
Also, my lord.
any source.
There is judgment of Honorable Apex Court, my lord. Any source.
Oh, then query licenses, queries in mining areas.
Yes.
What forest has to do with that?
Query is mining in mining areas, my lord. Stone
So-
crusher can be established beyond mining areas.
We understand. So if the stone is being extracted from quarries,
My lord.
what forest has to got to do with it? Unless it is maybe in the periphery of a forest area or in overlapping a forest area.
Under the minor mineral concession rules, my lord,
Yes.
we can also take notice of the transportation, storage, everything. There is a rule.
Yeah, High Court.
My lord, kindly appreciate one thing, my lord. There was a PIL file, my lord, claiming, my lord, as in Assam, stone crusher units are being used for crushing limestone. And my lords have passed an order that has to discontinue.
That has to be,
Discontinue. Stone crusher unit cannot crush limestone.
why?
The-
Which is that order?
My lord finds that order at page 134, my lord.
Let's see.
Relevant part starts at 144, my lord. 46. In fact, the order impugned before the Honorable Single Judge.
Just hold on.
Page 147, my lord, it peruses, my lord. Who are earning their livelihood by extracting sandstones from the quarries of the riverine area of the locality. The petitioner had approached this court by filing the PL 76 of 2020 inter alia containing that due to illegal use of limestone in the stone crusher units operated in that area, the livelihood of several persons have been adversely affected. According to the petitioner, limestone is included in Schedule X item of minor minerals under the Assam Minor Mineral Concession Rules and therefore could not have been used in the.
Now it has been excluded. That is the notification.
But-
It was not brought to the notice of the division bench.
But that notification was issued one day after the judgment, my lord.
Maybe. So
was-
now that notification is in force. So that judgment would not have any application.
From that notification, my lord, limestone has been taken away from minor mineral. That
Then-
doesn't mean, my lord, it has been included with forest department. What we are saying, my lord, that limestone being a minor mineral over which we have no jurisdiction, you cannot crush in our stone crusher unit.
Now it has been taken out of the purview of the Minor Mineral Act
Yes,
also.
ma'am.
Then
Yes. But that doesn't give us jurisdiction, my lord, to the forest department to crush stones, limestones, my lord. My lord, may kindly peruse the order impugned, my lord. That is relevant. On page 100. This was an order consequent to this judgment of this honorable court, my lord. Page 100, my lord, 6/3/2023. My lord, we are not against doing business in minor mineral, limestone, my lord.
yes, definitely. Maybe, but a day earlier. So this notification has come this order.
1 year later.
Oh, yes. 22. But this was not brought to the notice. This is definite. That's sure. Because the observation which is made is that limestone is included in Schedule 10, whereas the notification is this judgment is sub salientio actually.
Well, this judgment was passed on 2/3. That notification came on 3/3. my lord. One day
No, that is 22.
my lord.
That notification is of
Or
22.
22,
So this judgment has been passed in ignorance of the notification.
True, my lord.
It
But
would have no
but
force at
otherwise,
all.
my lord, will kindly appreciate, my lord. The limestone has been taken away from mines and minerals rules, my lord.
Yes.
But it has not been included with forest, my lord. So what we are saying, you crush it, arrange for your own crusher, not crushers regulated by forest department, my lord.
What is that logic? We don't understand. Sorry.
Because, my lord, they are being using limestone, my lord, for construction of roads, my lord, inferior quality. My lord, you kindly peruse the order
So
impugned.
you regulate that in a different manner. They'll get it crushed elsewhere and brought, then what you'll do?
My lord,
Is this order issued on ground of low grade limestone being used
yes, my lord.
anywhere?
Yes, page
Let us
100
see
for a
the-
moment, my lord. Page 100, the order impugned before the honorable single judgment.
Let us see. 100.
100, my lord.
Let's see.
Third paragraph, my lord.
Hmm.
Whereas the Honorable High Court in PIL number so and so had ordered so and so has clearly held. that
First of all, let us see the complete gamut of your order. Whether you have domain in these topics.
My lord, we
As
are
per
just-
schedule, so and so are graded for industrial use. What business do you have to go into that?
my lord, our business is Schedule Y. Limestone doesn't fall under Schedule Y as of today also, my lord.
Yes, all right. But is this the reason
Yes, my lord.
in your
That's the
order?
reason
And
that we-
it refers to the PIL judgment, which has been rendered in ignorance of the notification. You did not bring it to the notice
Then, my
of the
lord, you
court.
kindly peruse paragraph 1, my lord.
Yes.
Whereas as per Schedule X of the Assam Minor Mineral Concession Rules, certain minor minerals including
So
limestone.
this is erroneous on the face of it.
It has gone, but it has not been included in.
This order is non-est in the eyes of law. Take down. All right. The order is state. We pass a reason note.
Now, the impugned order dated 6/3/23 and 16/3/23. Because in one order, they have directed requested the annexure G and F.
D and F.
F and G, my lord.
Page 100 and 103, my lord.
Yes.
They have gone
As
to
a matter of fact, the
railways
council who appeared in that PIL, the council was under an obligation to point out this notification to the court. This is on account of your misstatement that judgment came to be passed. You stood here and consented. Yeah.
In fact, my lord, I was also not aware of that notification. my lord.
So ignorance is bliss is not the correct statement in this case.
True.
also. Annexure F and G.
Writ appeal is disposed of. Everyone is represented from the respondents.
My lord.
Yes.
Item number 18.
18, 24, 30.
So these are provincialization matters. They'll go to the special bench.
But here in this case, Lordship, I have challenged the virus.
Yes, the bench will take care of that aspect also. These matters are required to be considered by the special bench constituted for hearing provincialization matters, ordered accordingly.
Lordship, we are without salary for the last 1.5 years.
All right, you go to the bench and make a request for early hearing. Issue attendance लगा देना सामने से. 18 to
18 and then 24.
24 to 30 are also same category.
24. Twenty-four to 30. Special bench. M40.
Special bench.
Special bench.
Yes,
Obliged.
24 to 30.
24 to 30.
18 and 24 to 30.
Mhm.
Item number 19.
They have made the public to take.
PLPC वाला judgment दे दीजिए.
And
Sir
that
को
will
दे
be
दो.
required here.
Sir को दे दीजिए. PLPC,
Yes, what?
same order PLPC. ऊपर लिखा ना, all order कर दीजिए. PLPC.
I'm obliged.
Dispose of.
Obliged.
Item number 20.
Please, Your Worship. That pursuant to the direction of this honorable court in 15 PILs, an inquiry commission was constituted. And that order was of 2015. There was a reviewers visited. Eventually, the commission was constituted on 8/7/2019. Now thereafter, the commission has submitted a report to the government. And the government, my lord, has not considered another administrative committee to look into the matter, which is not permissible.
So ultimately, the impacts of the commission's report,
My
they will have to be objectively considered because they will have ramifications.
My
So
lord,
obviously, they can't just say, all right, the commission's report accepted, act accordingly.
yes, my lord.
The decisions will have to be taken.
But then, my lord, if your lordship kindly comes to subsection 4 of section 3, under which my lord has been constituted.
See, the report of a commission of inquiry may be accepted, may not be accepted. So now they are undertaking the exercise to find out what part is acceptable, to what extent it can be executed.
My lord, may I draw your lordship attention to subsection 4, my lord.
Please go ahead.
The appropriate government shall cause to be laid before each house of the parliament as the case may be, or legislature of the state, the report, if any, of the commission on the inquiry made by the commission under subsection 1, together with a memorandum of action taken thereon within a period of 6 months of the submission of the
Sir,
report.
tell
by the
us
commission.
any one judgment, the court in exercising jurisdiction while exercising jurisdiction under 226 can direct the government to table the report of the commission.
My lord, I am before your lordship, my lord, pointing out that, my lord, the report has been submitted more than a year back.
Maybe, sir.
And
We are
the
asking you, that's what the question is, sir.
My-
Whether such a direction can be given, that table the report,
My lord,
find out one judgment. This query we are posing for the reason I will tell you.
my lord,
That there was a tragedy in Rajasthan. That's called the Mehrangarh temple tragedy. The commission's report was presented in 2013.
Right.
There were about 217 deaths, but till date the report has not been tabled. The writ petition is going on. The argument which is being raised is the court cannot give a direction. So come out with one judgment.
my lord, I'll see to it, my lord. But then my submission with your lordship is
All
that.
right, we'll put the other side to notice.
My-
Issue notice. to the-
My lord. God bless.
Item number 21.
May it please your lordship.
Yes.
The other question is, my lord, whether a
What
retired,
has happened in the appeal?
my lord, wherein, my
It is
lord,
pending, Your Lord. It is pending.
Still not decided.
Not your.
Let the appeal be decided, sir.
my lord, the problem is that
On the last date also,
yes, my last.
you
time we
you
were
had
on-
short time after arguing the matter.
Last time we were on 21/6, my lord. Last
We
time,
don't have recollection. Your memory is sharper, sorry.
I'm sorry, my lord.
Yes.
Lordship, may kindly take up section 21 of the IPC, my lord. Lordship, may kindly take section 21 of the IPC, my lord.
21.
21.
Yes.
Honorable single judge, my lord, invoke clause 6.
Mm.
The 6 says, my lord, can you have IPC, my lord,
Mm.
just for a moment? It says, my lord, every arbitrator or other person
Mm.
to whom any cause or matter has been referred for decision or report by any court of justice or by any other competent public authority.
Mm.
And the finding of the honorable single judge was, my lord, the retired person by virtue of being an other person, that he comes under clause 6. And my submission will be, my lord, lordship will find it. With clause 6, my lord.
Yes.
Under clause 6,
Yes.
my lord, contemplates a reference to arbitrator or other person of any cause or matter in dispute. Cause or matter in dispute, my lord.
Mm.
So arbitrator, my lord, it has a legal connotation. It means a person, my lord, to whom a dispute has been referred to. Similarly, my lord, other person will be a public
provision is-
servant, my lord, to whom a cause or matter has been referred to. Cause or matter in dispute has been referred to for a report by any competent public authority.
Mm.
So all I'm trying to articulate, my lord, that existence of a dispute is a sine qua non for invoking clause 6.
Mm.
And in a departmental proceeding, my lord, strictly speaking, there is no dispute involved. There is only imputation of misconduct, my lord, by the employer against an employee. There is no lease inter partes, my lord. And imputation is, my lord, commission or omission of some act which has been termed as a misconduct in the extant rules. So since there is no dispute, my lord, clause 6 has no application.
Mm.
That is the first limb of my submission, my lord. And secondly, even if, my lord, we hold that a inquiry officer comes within ambit of clause 6,
Mm.
then the next follow-up question will be, my lord, whether it also includes a retired inquiry officer.
Mm.
And for that, my lord, honorable single judge relied on Alok Kumar's case,
Mm.
2010 5 SCC 349.
Yes.
And my respectful submission is that reliance is completely misplaced, my lord.
Mm.
In Alok Kumar's, basically, my lord, Supreme Court was construing the word other authority appearing in Rule 9(2)
Mm.
of Railway Servant Discipline and Appeal Rules 1968.
Mm.
And there, the honorable Supreme Court, my lord, concluded that this expression other authority has not been defined neither in the rules nor in the Railways Act. And also, my lord, there is nothing in 9(2) to indicate the intention of the legislature to give it a constricted or narrow meaning. And therefore, that was interpreted in the common sense that is understood and give it a wide definition, my lord. And there it held that other authority will also include a retired person in that sense.
Not there. Yes, Mr. Counsel, what do you say? Right now, you have a chance to redeem yourself. If we interfere in the inquiry report on the ground that it was carried out by an incompetent person, you will have the opportunity to redo the entire exercise
Yes, my lord.
through a properly appointed inquiry officer. But if these proceedings keep on dragging, what will be the fate after 10 years? Because apparently the view doesn't seem to be justified.
Your lordship, this para 46 of the judgment.
Alok doesn't apply. That is being wrongly applied.
No, your lordship, it is not wrongly.
See the provision, there.
Yes, your lord.
Read the provision. Brother, you put the provision on.
Para 26, lordship, will find Alok Kumar.
Yes.
That 9(2) has been quoted, my lord. Page 360.
Mr. Sharma.
Yes.
See, in Ravi Naik's case.
Ravi Malik judgment. Yes.
Yeah. The provision which was there is parameterial to the provisions which you are having. But in the case of Alok Kumar, the provision does not mention anything about a public servant. It says may constitute a board or other authority. Whereas in the case of the Ravi Naik, as well as in your case, it is clear the language is absolutely parameterial to appoint. Either it may inquire into or appoint any other public servant. So that was the only issue out here as to whether the particular inquiry officer can be anybody else other than the public servant. And if it is not, it has to be by the disciplinary authority.
But your lordship, the only difference in the Ravi Malik judgment of the National Film Corporation is the only difference that in the National Film Corporation rules, there is no definition of public servant. But in my case, in my rule of UCO Bank, there is a specific definitions to the public servant. That is in the 2N.
What is the definition? Read. IPC.
Definition referred to section 21.
21, we know. That refers to public servant in 21 as defined in 21.
Yes, sir.
So 21, how is a retired government servant covered under 21?
I am coming to that.
Yes.
That is public servant means a person as defined as public servant in section 21 of the Indian Penal Code.
Yes.
That is there. And thereafter, your lordship may kindly come to para number 46 of Alok Kumar judgment.
What do we require Alok Kumar for? First read 21. In which clause are you bringing
I am
your
coming to that.
retired?
I am coming.
First read 21, sir. Alok Kumar has been pointed out, doesn't have any connotation like public servant.
No, your lordship, para 46 is very clarified, your lord.
The rule is there. We have read the rule itself, 9(2).
Yes,
We have read the rule 9(2). There is no such connotation, public servant. Now read 21. In which clause your inquiry of supply?
Yes, 6th and 12th, your lord.
How does he fall? What was referred to him? Arbitrator
Or
to whom any cause. What is the cause? By any court of justice. So either it has to be an arbitrator. So he is not an arbitrator for sure. And nothing has been referred to your officer by the court of justice. So clause 6 doesn't apply.
Your lordship may kindly read 46, para number 46.
You just refer to your own rule definition.
No, your lord.
You said that in our definition, we have defined public servant, right?
We have defined and it has been supported by Alok Kumar judgment.
All right. Oh, read para 46. Firstly, what was the rule in Alok Kumar's judgment? What was the prevailing rule? Rule 9(2), will you read please? You have to apply a judgment to the facts of each case.
Yes, your lordship, it is there, your lordship.
Yes.
That another factor which we may notice is that the definition of the public servant appearing in the Penal Code 1860, reliance upon which was placed by the respondent, was not brought to the notice of the court while dealing with the Ravi Malik. In terms of section 21 of the code, a public servant denotes a person falling under any of the descriptions stated in the provisions. While it refers to the different kind of person, it also brings within the ambit every arbitrator or every person to whom any cause or matter has been referred for the decision or report by any court or any other competent public authority. Furthermore, as per the 12th clause of inclusion in this very section, even every person can be a public servant. In fact, in terms of section 21A, a person who is in service of the government or remunerated by fees or commission for the purpose of any public duty of the government is also a public servant.
The report is in report by Kumar नहीं आलोक कुमार को रवि मलिक there is comment आलोक कुमार that Ravi Malik did not take into account the question so wider and you come to 21. 21, sixth. Let us split the section in two parts. Every arbitrator or other person. So other person can be even a retired public servant. There is no dispute. There is no restriction. To whom any cause or matter has been referred for decision or report. So inquiry report is there. By any court of justice or by any other competent public authority. So the disciplinary authority, can you deny that this disciplinary authority is any other public authority?
Cause or matter in dispute.
No. No dispute. Cause or matter has been referred for decision or report. So report is an inquiry report.
Cause or matter. Lordship, may kindly see, arbitrator, my lord, is a person to whom a dispute.
Arbitrator, forget about arbitrator. Then come to other person.
Both. For
Or
both
it is or. It is or.
My lord, for both expression,
Yes.
arbitrator or other person, it has been referred in any cause or matter.
For decision, cause or matter. So matter, inquiry report is a matter.
My lord, cause or for arbitrator, my lord.
Arbitrator is a different category, sir.
I
Other person. So
appreciate-
other person, matter has been referred for preparing a report. That would be an inquiry.
My lord, Lordship, may kindly just my learned friend referred to para 46.
Yes, wherein
Lordship,
There
may
is some
kindly see para
observation that-
45 and
Yes.
55.
Yes,
In that light, my lord, Lordship may kindly consider 46,
yes.
para 45.
Hmm.
Reliance placed by the respondent upon the judgment of this court in Ravi Malik
Hmm.
is hardly of any assistance to them. Firstly, the fact and the ruling falling for consideration before this court in that case were entirely different.
Gentlemen, in para 46, virtually the Supreme Court goes on to say that Ravi Malik is sub silentio.
My lord,
And that is correct. Because 21 was not considered.
my lord, yet the Supreme Court says, my lord, the two expressions are entirely different. There is no argument advanced, my lord, before in in Alok Kumar's case touching on section 21. No argument was advanced.
Irrespective thereof, the Ravi Malik was cited and the Supreme Court considered it in light of the fact that the wider definition of a public servant was not considered in Ravi Malik, even though the rule says public servant as referred to in 21.
But in 55 says these two expressions are not interchangeable. Lordship, can you see 55? Public servant cannot be equated to the term other authority. Both these expressions cannot be treated as interchangeable or synonymous.
So there,
They have
we are
different
not concerned with,
connotation.
we are not concerned with other authority.
My
We are concerned with any other person.
my lord,
So any other person can be a retired public servant.
my lord, in terms of section 21, my
Yes.
lordship may kindly appreciate. In my lord, in Alok Kumar's case, no argument was advanced touching on section 21 because that question never arises there.
Still the Supreme Court considered it,
That's an
made a
obvious-
comment.
My lord, in view of 45 and
Once
55,
Ravi Malik was cited and thereafter considering Ravi Malik in light of the fact that 21 was not considered, that is not an obiter, sir. That is a ratio descendi.
my lord, no argument was advanced touching on section 21
Ravi Malik
because
was
public
cited.
servant was explained in section 21
Anyhow.
because that was
IT institution. It is subsequent that 2010. But it's other that. There been this difficulty. Then it has been following the view. Ashok.
Why a constricted? It's a discipline is a precedence in the because see that is why provision has been it's and it's only that's why the definition is made by make it within 21 60 page pretended. Very good. Yes, carry on.
my respectful submission is that, my lord, in Alok Kumar's, this
21 was not argued, all right.
public servant has never fought for consideration, my lord. So
Okay,
no argument was advanced, no occasion to consider that.
very well.
So this observation, particularly in the light of 45 and 55, my lord, this is a passing reference, my lord. This is an obiter. This is not a ratio.
Very well.
And secondly, my lord, this,
But can you deny the fact that in Ravi Malik, 21 was not considered? Now come back to Ravi Malik, whether 21 was considered or not.
not considered.
Not considered, then we have, even we can say that it is per incurium, or sub silentio at least.
My lord, I'm not even in Ravi Malik's. I agree that factually distinguishable.
Yes,
There is no dispute on that point.
then,
I'm not relying on Ravi Malik's, my lord.
okay. Then you come back to the definition.
Section 21.
Yes.
6.
21, sixthly, it's a clearly covered. No doubt about that.
My lord, this report, with all due respect, my lord, is a report contemplated under chapter 9 for public orders, for public tranquility and order. Because this, my lord, it says every arbitrator or other person to whom any cause or matter has been referred to for decision or a report,
Or a report.
for
Yes.
a report. Now,
Now, who can refer? Either the court or a
or a
public
public
authority.
authority.
So a public authority, when they are drawing parity simply for the purpose of the definition of a public servant, we'll have to go for a wider interpretation.
Was
All right, sir, this is now second note has been heard enough. Thank you.
There's just one more, another limb of my argument. Another limb of my argument.
Yes.
This 76 regulation, my lord, is framed under section 19 of.
Get your
banking-
appeal decided on merit, sir. That's the only way your client can proceed.
Well, just one more. This 76 regulation framed in exercise of power under section 19 of Banking Companies Acquisition and Transfer Undertaking Act. Now, Lord, may kindly see section 14 of the
Whether this argument was there before single judge?
My lord,
What argument you are canvassing
my
now?
lord, that was argued, but unfortunately it was not reflected. It was
Then-
my
then-
will
then
not deny that. It was not
Review,
argued.
review is the remedy, sir.
Technically, but my lord, my learned friend will correct me. if I'm wrong.
We'll simply say that this argument is being raised for the first time,
My-
not
my-
raised. Yes. So we'll not allow you to raise an argument which is not reflected in the single bench judgment.
That I appreciate, my lord, but.
Yes.
But the fact of the matter is this question was raised, my lord. but
Then
unfortunately
you
not reflected.
seek liberty, file a review.
Proper remedy, of course, review. I can't deny that, my lord.
Yes. So
Can't deny that. I can't deny that.
to that extent, you can always seek liberty and file a review.
Of course I can.
Hmm.
Of course I can. That remedy is also already available, my lord.
So no decision has to be taken right now.
I'm leaving it till option.
So then all right, we'll dismiss your appeal on merits. Okay.
Item number 22.
May it please, your lordship. The learned single judge remanded the matter, my lord, for adjudicating by the state respondent. No, my lord, we have only one grievance. We're telling the part judgment of the learned single judge. That is, my lord, the learned single judge came to the conclusion that so far teaching experience is there, my lord, while pursuing the research study like MPhil and
MPhil.
PhD. If I did not, if I pursued that without taking leave, in that case, my lord, I will get no marks. But my lord, there are certain explanation by the UGC as well as notification back in 2018. They have said if without taking leave, if I have, my lord, worked there as well as I have pursued the research study, in that case, the teaching experience will have to be counted. I'll take your.
Probably we have taken a different view.
In Asarani Bohmos case, my lord has already.
Yes, we have decided this issue against you, sir. You can see the judgment if you want.
WA lordship
My lord,
367
But I'll take your lordship's 2 or 3 pages, your lordship kindly see. At page 84 first, in regard to the OM dated 2012.
Take out that judgment. You are having copy?
Lordships, I will supply in lordship. Lordship has decided it on 28/4/2023 lordship.
20th April.
Lordship.
Asharani.
Asarani Bohma lordship.
Read April 367 of 2018.
My lord, in that case, can I take your leave? Let me go through it. Let's some other.
Definitely.
That particular issue lordship has.
Precisely that issue was.
Lordship, that particular.
Council, senior council, Mr. The praise for time, list after summer vacation.
Item number 31.
Saikia, Advocate General, Mr. Saikia, and Mr. Goswami. Mr. Saikia, we have requested you to find out CCTV system.
I have received the information.
Okay,
In 2 phases, we have done only in 4 police station out of 3. I have just received the information. Lordship. Actually, the printout is on the way.
we will pass it over.
No, just right now I can.
Okay.
Yes.
What about service of notice?
Yes.
What has happened?
In first phase, Lordship, out of 100 police stations, we have completed it. And second phase, out of 232, we have completed 227. And in 2-3 days time, the remaining 5 will be done. Insofar as Assam is concerned.
And they are connected to a monitor room, central. What is the status? Are they interconnected? Control room has to be there.
Let me take instruction on that.
That will improve the entire system.
Yes, Lordship, let me let the matter be called up after 10 minutes, Lordship.
Okay, very well. Ms. Goswami, what is the status in us? Let's check.
This is with regard to my installation of CCTV in the police station with the central control.
Yes.
We are making efforts to get that, but otherwise, my lord, the CCTV is already installed, my lord.
In every police station.
Yeah, 110 police stations.
Okay. But unless you connect it to a central control room, the control room remains with the local people. They may choose any moment.
As in this case, my lord.
To snap it, yes, precisely.
It has happened, my lord. But we are making efforts. Only there is some connectivity issues. My lord.
That will be there in your state.
Yes,
That connectivity issues will be there. But now we were reading about the latest internet technology being provided in the state. So things should improve with that.
We are making efforts, my lord.
Yes.
Lordship, so far as Assam is concerned, all is connected with the headquarters at Ulubari.
Okay, wonderful. That's good.
And my lord, there is another issue relating to Arunachal Pradesh service of notice through PP. It has gone to the court of the JMFC, but yesterday was the date, my lord.
Okay.
Then there's change of guard, my lord. That special PP has been appointed. Next date is 29. Before that, service will be effective. That is my instruction.
Okay. Advocate General Assam, Mr. Saikia, has made a statement about that in phase 1, 100 police stations in state of Assam have been provided with CCTVs, and in phase 2, installation has been and commissioning has been done in 197 police stations. In the remaining police stations, the installation and commissioning shall be completed in the coming few days. He further informs that all the CCTV feeds are being monitored at a centralized control center in Ulubari, Gauhati. Mr. Goswami, Additional Advocate General, Arunachal states that CCTVs have been installed in all police stations at Arunachal Pradesh, in the state of Arunachal Pradesh, but till date, a centralized control center has not been established because of connectivity issues. So we hereby direct that this process shall also be expedited. Mr. Goswami further submits that steps for effecting service on the accused in criminal petition number 118/2022 are being taken, and they will positively be served with the notices of the said petition by 29th of June. Re-notify in August.
Less, my lord.
Much of.
Item number 32.
The sole appellant died, we have filed an application for impleading. That is not currently filed. Lordship. We already filed Lordship the IA.
Same council.
His legal years should be insignificant.
That application has already been
We have
preferred.
filed, but the application is not there in the file.
preferred to bring the LRs of the appellant number 2 on record. The registry shall tag the same with the file and list the matter after 1 week.
Item number 34.
Lordship, this matter concerns seniority of respondent number 1, my lord.
Disposal again, accordingly. My lord, on the last occasion, that preliminary objection was, my lord, rejected by.
You gave it up.
I gave it up. Yes, man, I gave it up. The matter has to be.
We'll admit the
My
appeal
lord,
and then
we'll have
hear.
it for hearing, my lord. Fine.
The appeal is admitted. Respondents are duly represented, thus notice need not be issued. List for hearing
Lordship, that's specifically.
in August.
Lordship. Much obliged.
The person has already been promoted, my lord, after the learned single judge's order.
And nobody is before my lord, nobody is affected by that order other than the association and few of his members.
Before PWD, when the impugned order before the 11th single judge was passed, there were many engineers were represented, my lord. So all that I am saying is that let it be subject to the outcome, my lord, the promotion.
My lord,
Always are. The
Always
matter
is-
is sub judice, so always.
My lord, he may claim equity later, my lord. Lordship may just add that one line, my lord.
When the interim order, my lord, was the rejected, no
No,
orders. were
interim
passed.
order was not
Why,
rejected,
my lord,
my
for his satisfaction, these orders are being passed. my
The
lord.
issue of locus also
Let it
came up.
come up for hearing, Mr. Fukan. We'll see.
Any specific date, my lord, in August? Any date, my lord.
22nd August.
Deeply obliged.
Item number 35.
Mr. Mazumdar,
My lord,
this is the first instance
my lord,
wherein, I'll tell you,
Right.
in my 35 odd years, 38 years now, I've come across the police claiming to have registered a post-investigation FIR and with pride. You know the concept of post-investigation FIR.
my lord.
Your OC and your SP comes and state with pride, yes, you have registered a post-investigation FIR. The first FIR, forget it. Second FIR, forget it. We conduct investigation and then register FIR on the basis thereof. This procedure, in my experience, it's alien to my knowledge. Maybe some new kind of record is being created. And it was with great pride it was stated. Your SP, she fortified that assertion.
Now the things have changed after his lordship.
All right, what has changed? Let's see. What has changed? Stop the, stop the. इसमें एक लाइन ऐड करना पोस्ट इन्वेस्टिगेशन डॉक्यूमेंट है ना clearly appears that this FIR was registered so as to somehow or the other justify arrest of Rukia Khatun.
May it please your lord.
Yes, please.
This is an appeal preferred by the state of Assam Lordship in the education department. We are basically agreed by the learned single judge's order because in Assam there are several types of TET. One is the state TET or called Assam TET Lordship, which covers the general areas.
Okay.
And when we have initially started the recruitment process with having the candidates having the Assam TET in 6 scheduled areas comprising of few district lordship, where there is no Assam TET candidates or most of the vacancies could not be filled up because the Assam TET candidates prefer to work in the regular areas, lordship.
Yes.
They don't prefer to go to the
6 scheduled areas. Yes.
and in 6 scheduled areas, the students, maybe because of their little bit backwardness, lordship, they could not cope up with the state TET. And there are less number of persons having Assam TET. As a result, the schools are not having full number of teachers. There are huge vacancies. As a result, lordship, the state of Assam has considered and after a conscious decision, took a decision that there should be special TET for 6 scheduled areas.
Okay.
That lordship will kindly find that advertisement at page 16.
Yes.
On 22nd September 2012, this advertisement was issued. As a part of implementation of Right to Education Act 2009, the Government of Assam Education Elementary Department has conducted teachers eligibility test for the first time in 25/1/2012. And eligible candidates qualifying in that have already been recruited in assistant teachers under SSA, Assam in lower primary and upper primary schools in 2 phases. It is for general information that considering the availability of category of wise vacant posts of teachers in lower primary and upper primary schools in the 6 scheduled districts, it is decided to hold teachers eligibility test for the 6 scheduled areas, namely Baska, Shirang, Dima Hasao, Kokrajhar, Karbi Anglong, and Udalguri, and applications are invited for the same. The eligibility criteria for the candidates to appear in TET are as follows. The candidate must be permanent resident of 6 scheduled areas. So the main objective was to promote the students of that area so that the vacancies are filled up and they get the opportunity to
So
work.
that was a virtually a local reservation.
Local reservation.
Yes.
And nobody challenged it, lordship. And after that, lordship, the candidates received this certificate at page 17.
Yes.
The certificate they received was
So
teachers.
you have conducted that examination?
We conducted that.
The aspirants passed out.
Passed out.
Okay.
And later on, this is the certificate. Lordship will kindly see. Teachers eligibility test 19 December only for 6 scheduled areas.
Okay.
So they acquired the teachers eligibility test qualification.
They are residents of that area only.
That area, and they can apply for that area.
That area only. On the basis of this certificate.
On the basis of this certificate, and very clearly says only for 6 scheduled districts. Subsequently, there was advertisement for the state.
Of TET.
Of no, for regular
recruitment
at page 41.
Okay.
30th of August 2016, this advertisement was issued, and lordship will see the number of districts here, serial number. Total post is 413. Science teachers and assistant teachers 2,934, and 21 districts are included for this recruitment process. So we did not have BTC areas
Any
or
of the
other
BTC
6 scheduled areas in this recruitment process. Everybody participated.
Simultaneously, one more question. Did you in the meantime, in this period, have any recruitment in the BTC area?
Yes, yes, sir. That is going on.
That's going on.
That is going on. So what is the case here? Some of the candidates who are having 6 scheduled area certificates, they also applied. And after preliminary scrutiny, lordship, we have put them in the select list. And when we are finally doing the verification,
document verification,
then we found that they are having 6 scheduled area certificates, which is not eligible for the general areas.
Okay.
So that is the case. The learned single judge found that we have done discrimination.
hostile
And when we
discrimination.
clarified the issue by a after verification, that later is put to challenge, page 18. Here, this is the later issue after the advertisement. Serial number 1, the candidature of candidate who have passed that for BTC and 6 scheduled areas, their candidatures shall not be accepted. In the TAP qualified certificates of those candidates, it was clearly mentioned that they can apply in.
They can't apply
in general areas. So that is my case, lordship.
Okay, then what has been done? What is the direction?
The learned single judge. The learned single judge found that this is discriminatory and we are changing the rules of the game. Our advertisement is very clear. It is for Assam. And the persons who have that 6 schedule area certificate.
Is the order stayed? Has the order been stayed? Because these writ petitions are pending since
Yes,
70.
only one person is left, but the bigger legal question is involved. The others are not appearing also. See,
What have you done to them after select? You didn't select them? Didn't appoint them or what?
no, till
What
now
is
they
the
are not.
status of compliance of this order?
We have immediately filed it. Apply for it. No, we
Ms.
have filed
Saikar,
the appeal.
we want to
Whether
know
the
whether
stay
there is a
was-
stay operating or not.
That is what I'd like to just check.
Do you know, Mr. Counsel?
Lordship, this petitioner, this respondent has not been appointed, my lord.
Has not been appointed.
Though
Only one person is in there. Maybe others have got.
No one else has come out for contesting.
One is here. My friend is here.
Then the only way out is we admit the appeal.
Yes, Lord.
Then fresh notices will have to go.
Lordship.
The appeals are admitted, admission notice. Only respondent number one. Respondent number one is represented. Thus, steps for service upon the unserved respondents be taken in 7 days whereafter process be issued to such respondents.
Deeply offensive.
In all cases.
Item number 39.
Check represented con case. So in whichever cases there are names, you find out. Otherwise, notice will go.
My lord, I appear for the applicant in this matter, Your Lordship. My lord, I pray for a week's time I file an affidavit of reply against the affidavit of NHITCL and also the state.
Affidavits on behalf of the respondent NHIDCL and the state of Mizoram have been filed recently herein before. Then counsel representing the petitioner as well as learned counsel Mr. Nair appearing for the respondents numbers, private respondents, comma, raise. Learned counsel representing the other parties, comma, pray for and are granted 4 weeks time to file counter to the affidavit filed on behalf of the state in the meantime.
For respondent number 5. An affidavit in IA 89022 2022. That affidavit may be taken same as in the writ appeal.
And counsel, your good name, sir?
VK Jindal.
VK Jindal submits that he has filed affidavit on behalf of the respondent number 5
In IA.
in IA number so and so, and that he may be allowed to adopt the same affidavit in this appeal. Ordered
One
according.
more prayer, Your Lordship. The order impugned here in this writ appeal. Some of the respondents, they have filed the execution case in Aizel, and that petition was dismissed. Against that, there were 4 petitions filed. Against that dismissal order, they have filed a civil revision under Article 227 in respect of the order which is the subject matter of this writ appeal. My prayer is this, Your Lordship, those 4 civil revisions may also.
Who are the parties in that those revision?
They are the respondent hearing.
Do you know, Mr. Nair, are you aware?
Yes. I have got.
You give the numbers,
I have got the list,
Mr.
Your
Jindal.
Lordship.
You just file a small application for transferring those files and listing them with this petition. Then we'll pass the order.
Otherwise, Your Lordship, I have got the number.
Please file the application so that Mr. Nair may know on whose behalf
At least my submission be recorded. In the meanwhile, I'll.
you, Mr. Jindal further submits that some of the respondents, comma, they have filed petitions under Article 227 at the Aizawl bench which are required to be heard along with this writ appeal. He is permitted to move an application for seeking such a joint hearing. List up 4 weeks.
My lord, I pray, my lord, before your lordships, my lord, if any affidavit has been filed by the respondents, kindly be served on the applicant, your lordship.
Applications, affidavits, if any, filed on behalf of the respondents shall also be served upon the counsel for the petitioner through email for the appellant.
Date may be given, we are from outside.
My lord, my advocate on record is
27 July. 27 July. What are you saying, madam?
my lord, my advocate on record is a local counsel, so we can try and record.
Okay, very well. So we delete that email part. AR is here. She'll receive the copy. Okay.
Deep knowledge.
Item number 40.
But may I please? But here I have received an affidavit in reply to our affidavit in opposition, Lord. But in the reply, Lord, I have seen that so many allegations have been brought against the officers, Lord. But I have to verify the records of the tender, Lord.
Affidavit has been filed just now.
No, yesterday we have received.
Yesterday.
Lordship.
In fact, the affidavit which has been filed is full of falsehood, my lord. Actually,
Affidavit on their behalf.
in the reply, we have pointed out.
But then you pointed out, then he needs to get instructions
I
on
have to
that.
verify with the records.
Mr.
Lordship,
Nath submits that affidavit in reply filed on behalf of the appellants contains grave allegations against the officials of the state government, public department concerned, finance command. He needs some time to take instructions on such allegations
Matter
to verify the facts asserted therein.
Matter we called on 26th, my lord.
There is urgency. What is the urgency? Let it come after summer vacation, please. Please re-notify on
Pending bill to the.
21st July.
My lord, that pending bills will, there is an interim order.
Already there is an
The
order.
interim order
There is an order.
dated so and so shall remain in currency. Supplement.
I'm told, my lord, that order is not recorded.
Just let's check.
That they will not make further payments to the respondent number 5.
Mr. Nath assures that no payments shall be made to the payment of bills of the respondent number 5.
Yes.
Shall not be sanctioned.
Deep level.
Respondent number 6.
Six.
Let's check, please. Then you will come for a correction. The earlier order was any action taken by the respondent shall be subject to further orders of this court. Okay. The payment of bills of respondent number 6 shall not be allowed in the meantime.
Deep level.
Supplementary list for orders. Item 44.
That this honorable court.
Otherwise, also there is a challenge to the provisions of the act.
So we are preparing the affidavit, lordship. We need some more time to complete the affidavit and file it, lord.
Okay.
On by the order dated 26 May, my lord, this considering that an interim order may be required, my lord had issued and.
Challenge to provisions of that, madam.
My lord, I leave it to your lordships, my lord.
Let
I
their
just point
affidavits
out-
come.
I just point out one thing, my lord, because the Advocate General also will support me, I believe. That in view of the impugned NOC issued, wherein there is not even any provision for issuance of NOC by the Deputy Commissioner. On that basis, what is happening is some private group of individuals, they are running the market, and we are electing panchayat, my lord, properly duly constituted committee. We, because there is no NOC, we are unable to do run our market, my lord. Whether this kind of a situation, whether the Advocate General will support this situation.
We
to
don't know.
continue.
We don't know. He'll come out with the affidavit, then only he can make any comment.
Very interesting. They have not made the main party, that Panchayat and Rural Development. They have made as a pro forma respondent.
In fact, it was, they had been arrayed as proper respondents, but I made a request that since I have no issues with the Panchayat department and therefore it may be treated as a pro forma respondent, but they continue to remain on board. And my lord, this coming from the Advocate General, my lord, the case that I make out, it supports my case, the case.
No, I am not
which I have
supporting
made.
anybody, Lordship. I am
Without
supporting
their
cattle
affidavit, then
preservation.
he can't make a statement randomly. Where is the pro forma respondent even? We don't see anyone. Come to the cost title, page 5.
There is in the manner, he made arrayed as proper party.
The other day, they made a request that
Yes,
they
I
have,
made a request that I stand by
But the
that
cost title is there.
the cost rate there, it is not indicated, but they made a verbal
request.
request the other day that they should be pro forma respondent.
Okay, so this is an amended cost title. Page 3.
Page 5, my lord.
Page 5,
Number 3 is there, yes.
respondent number 3 is there, but
So the respondent number 3 is there, Mr. AG.
yes, Lordship, it is, they made a submission very categorically.
Oral
Even-
submission was there.
Even today, they are reiterating,
Even I say that, even I
Very
stand by
well.
that.
Okay.
but it is, the department name is also not correct here. Panchayat and Rural Development Department,
Yes.
PNRD.
Anyhow, Learned Advocate
But
General.
we have prepared the affidavit, Lord.
Yeah, I pray that this honorable court may not allow that anomaly, or it may be, my lord, even if I am a constituted
Yes.
committee, my lord, I elected panchayat, even if I'm not doing it's all right, my lord, I do not need any positive order in my favor, but let the private individuals who are running the panchayat market, my lord, let there be some observation, my
What
lord.
observation? We should stop them from doing the business.
My lord, my lord, I leave it to my lords. If my lords.
Let the
think
affidavits come, then we
that-
consider. Affidavits on behalf of the respondents have still not been filed. One more opportunity is granted
And my
to Learned Advocate General and then counsel presenting the other respondents to place on record their respective affidavits in opposition. Re-notify on 18th July.
My lord, on that day, on that day, my lord, that interim prayer may be kept
We'll
open.
let
for
the affidavits come, then we'll do that, madam.
My lord,
So already the prayer is there. It's on record.
Observation
We have
is also
recorded
there.
your request.
Yes, that
We'll
is there,
consider
my lord.
it. Yes.
In fact, the Advocate General, my lord, I thought he will be saying that if that market which is running against the Cattle Preservation Act, which my learned friend will be supporting, my lord, if that may not be permitted, my lord. I leave it to the
The
state, my
NOC
lord.
which they have challenged, it is a very innocuous challenge, Lordship.
Let's see. Okay.
The NOC is given subject to fulfillment of all the requirements of
conditions.
the Cattle Preservation Act.
Cattle preservation.
That is there on the paper only. That is there only on the.
There
paper,
are
my
so
lord.
many things, madam, which only happen on paper.
Exactly, my lord.
Then
I
we
leave
take
it to my lord.
cognizance of everything.
The Advocate General is there. I'm sure that.
Yes, we hope that, we hope and trust
My
that he will
only
take care.
concern that my eggs should be protected. That is my only, who runs the market, I am not bothered, Lordship. The eggs should be.
Yes,
Very-
precisely.
I'm
Highly
grateful, my
obliged,
lord.
Lordship.
Item 45.
Yes.
May I please, Your Lordship? The brief facts are, my lord, I am appearing for the Numaligarh refinery, my lord.
Yes.
Now, there is an expansion project of the refinery going on. We have floated a tender, my lord. With the bid of the respondent here in my lord, it was rejected.
The arguments have been heard, the judgment is reserved.
Exactly, my lord.
So let
And
it come out.
My lord, that
This
is
is
what,
preempting the issues.
my lord, the issue is that the interim order was rejected, my lord.
All right, but
On
the
30th,
final
my
arguments have been heard.
Final, my lord, if the learned single judge had fixed the date, that we are, they were delivering the judgment within a short time, my lord, we would have waited, my lord. 2 months have gone by, my lord, from the judgment.
That's all right.
CAV, my lord.
Honorable Supreme Court even says 3 months is time wherein the
That is
judgment
there.
can be expected.
But passing an interim, it is always subject, my lord, subject to the outcome, my lord. On 30th of January, when the interim order was rejected and the final decision was made subject, my lord. Nothing has changed from then to now, my lord. Whatever we have done, it is still subject to the outcome of the judgment, my lord. What was the necessity of staying the process, my lord?
Well, if bids are accepted, orders are issued, then it creates complications.
It is subject. to
Let
that
wait for
appeal.
the judgment, hope that the judgment will come out before the vacations.
That is the difficult part, my lord. If it had come out, my lord, because the project itself has got delayed, my lord. We were supposed to allot the work order in January, my lord. Today we are in June, my lord. The entire expansion project is being delayed because of this, my lord. Lordship will kindly consider that, my lord. Let us go ahead, my lord. If it is subject,
At this stage, to interpret that will be too much. We can only request the learned single judge to dispose of the petition. The petitioner is aggrieved by the appellant is aggrieved by the rejection of its prayer for interim relief by the
no, my lord. I am
by the
granting of the interim relief.
declining of the interim prayer by the learned single judge by the order dated 30th January 2023 passed in WPC number so and so. This court is apprised that final arguments just look into that. Yes. This is later. Are you sure? Where is the order? What is the page of
The impugned order, my lord, at page 376.
okay. Mhm.
And
Is
the
aggrieved
earlier-
of the order dated 13 June 2023, whereby, the appellant has been restrained from taking further action on the basis of the LOA issued to the
private respondent, my lord.
private respondent. Stop. The court is apprised that pursuant thereto, final arguments
Not
having-
pursuant thereto, my lord. Arguments were heard before that, my lord. The
Okay.
judgment was reserved on.
all right,
4th
and thereafter the stay was granted.
Exactly, my lord. It is granted after this reserved, judgment was reserved, my lord.
This is unacceptable, sir. Absolutely. This is absolutely beyond all canons of justifiable action.
If your lordship, I'll address this point. my lord.
No, you address the point. We are not at all pleased with the manner in which
No,
these things are proceeded.
I'll address my lord.
Yes,
To your lordship, my lord.
all right.
What is happening?
Yes.
My lord.
Come on the principles first.
No.
A judgment is reserved and thereafter prayer for interim relief is,
No.
then the learned single judge should have recused, we feel.
No, judgment is reserved, my lord.
Yes,
But the learned single judge doesn't become a functus of officio, my lord.
yes.
Reserved. But what they have done, kindly see, on what basis in opinion, on the, my lord, they could not have.
Can we have the cause list of 13 June, please?
13th,
Let's have the cause list, how the matter came to be listed.
13th of
They
June,
filed an IA, my lord. On 12th, it was mentioned, my lord. It was listed on 13th.
13th. It was listed on 13th.
Sorry, sir, no, we don't, we just are not
Kindly see,
agreeable to this.
on what ground, my lord, I'll show your lordship
Whatever
at page
the,
12. No,
at
kindly see.
best, a request could have been made to
No, my-
expedite the decision of.
No,
the petition.
1.17, kindly see, my lord, that at page 12,
Yes,
page 12,
yes.
page 12, 1.17.
12 of what?
Page 12
Of the writ appeal?
yes, appeal,
Yes.
1.17.
Mhm.
That the work order was to be allotted on January 2023
Hmm.
itself, but due to pendency of the present writ petition, same has been delayed. In the aforesaid background and since wide order there 31 2023, no interim order was passed and a bidding process was made subject to further order
Hmm.
of this honorable court. The appellant, in addition to the opinion of the dealing counsel, had also by the email dated 18/4/2023 sought for a legal opinion from the Additional Solicitor General of India, Supreme Court of India, on the future course of action to be adopted in the matter in view of the overall delay in implementation of the project. Now, my lord will kindly see what is the prayer that has been in at page 48. Page 48. The prayer in the writ petition.
Yes.
Page 48, kindly see the prayer C, my lord.
Mm.
That this honorable court may be pleased to an order saying all proceeding in connection with tender for supply of reactor regenerator, including the issuance of letter of acceptance contract by the respondent. Now, what they have done, kindly see the interim order that was passed by this court.
Subject to.
On subject to further order of this court.
Yes.
Now, my lord, a LOA has been issued.
Hmm.
My lord, what, my lord, with great respect, I am saying, my lord, what prevented
Mr.
them
Das,
to
Mr.
file
Das.
an application before the learned single judge that, my lord, from 2nd of January was the order, 2023, where our rejection was made. The matter was taken up by the learned single judge. Continuous 10 days hearing was done before the learned single judge, my lord.
Yes.
And on 4th of April 2023, my lord, it was concluded. And I am telling, my lord, with great responsibility before your lordship, the understanding before the court, I am telling today itself, was that they will not go ahead. With this, my lord, we did not prefer any appeal. I am telling with great responsibility. I will not say anything with, this is what they said, that we will not go ahead with any of the work order. Let the judgment be. My lord, they should have come before
This
the
is
court.
trying to play hide and seek with
My
the
lord, I will
Mr.
tell with great, my lord, responsibility. That's why we did not prefer. My lord, we give a lot of opinions, my lord. That doesn't mean
You could have
binding
filed
on
a
the court.
clarification application, Mr. Decker.
This is not done, my lord.
You could have filed a clarification application.
Yes.
You could have sought permission that
Correct.
our work is being delayed and we are being caused, losses are being faced.
My lord
So
will
allow
kindly-
us to issue the LOA.
My lord will kindly consider, my lord, there is no interim order restraining us. my lord.
Maybe.
My lord, it is made
What
subject to the.
prompted you? What prompted you?
Because it is because of the delay, my lord. With
No,
utmost
no.
respect, my lord.
You could have filed an application seeking early delivery of the judgment.
My lord,
That was the only way out, sir.
Lord will kindly consider, my lord, that is difficult for us. My lord, we have taken a legal opinion. My lord, it is still subject. Lordship will direct. It is still subject to the outcome. my lord.
All right.
Whatever
So-
judgment is passed, my lord. Because after reserving of the judgments, my lord.
Yes, when was the judgment reserved?
4th of April, my lord.
So heavens were not falling.
Heavens were not falling.
So
my
you
lord,
could have waited for a while. You could have made a mention to the learned single judge
Yes.
that the things are
difficult.
very urgent. We need a judgment in time.
It is difficult. on our
That
part
that
to make a
mention could have.
mention.
Why not? It's done. Complaints are filed in
Deliver the
writing.
judgment, my lord, with utmost respect, my lord.
Complaints are filed in writing. We received them.
Complaints are filed. We are a public sector undertaking, my lord. We want
Yes.
not go to that extent, my lord.
My lordship,
My
one.
lord, we have taken every precaution.
Mr. Deka, you could have just made a request. Oral request would have served the purpose.
Lordship observes that if the judgment is delivered, my lord. The thing
We
is
can
that
make an
the work
observation.
is suffering, my lord. We have got no preference. We do not prefer either the respond number
We
4
can
or.
make an observation that you will make a request to the learned single judge for preferably deciding the petition before the vacations.
My lord gives the liberty.
Against your lordship judgments, we go to Supreme Court. But there is no stay which is granted by the Supreme Court.
Learned
Even
counsel,
your
Ms.
lordship
Deka submits that
doesn't do anything.
rather than pressing for the prayer made in this writ petition to set aside the order dated 13 June 2023, his client would be better advised to make a request before the learned single judge that the writ petition, which has been closed for judgment, may be decided expeditiously and preferably before summer vacation. In view of the submission so made, the instant intra-court writ appeal is disposed of, leaving the appellant at liberty to make the appropriate prayer before the learned single judge.
Obliged, my lord.
Item number 46.
Interlocutory application is also disposed of.
My lord, this is with regard to settlement of a market. Admittedly, when I submitted my bid, my lord, the requisite documents were not given. According, no, fine, my lord, it was not. But the tender contained a condition, my lord, that if I am the highest bidder, there are some lacking, other than court fee and the earnest money, they can give me 3 days time. They'll give me 3 days time to meet it.
Okay.
They issued a letter that was never received by me. Then, my lord, they took a decision to give it to the private respondent. I come up before your lordship. This honorable court directs that the appeal that has been filed by me be taken into consideration. The appeal was taken into consideration, said that you have given it to the second bidder without government approval, that is bad. So accordingly, my lord, it was directed to be settled with the highest bidder. I was given now the notice under 9-10, clause 10 of the tender. I fulfilled that, my lord. They asked me to deposit the amount. I deposit that. The, my lord, order is passed now in my favor. They come up before this honorable.
In writ.
In writ, my lord, saying that I was not heard. This honorable court interferes with the orders and remands back the matter to the appellate authority. But my lord, in the meantime, maintains status quo. That I was running the premises, the market, it goes, my lord. There's around 20 lakh rupees difference, my lord. between my rate and his. Now, my lord, what has happened? The tender, the appellate authority again hears both the parties, comes to a decision that no, he has now satisfied, he will continue with the market.
Okay.
That is when, my lord, they come up before this honorable court by the present writ petition. This honorable court, my lord, takes a view that the highest bidder would be the highest valid bidder. There is an order, there is a judgment of this honorable court, wherein it says that, my lord, the highest bidder in the panchayati terms, wherein, my lord, the approval, if given to the second, is to be taken from the government, would be the highest valid bidder. And the private respondent being the highest valid bidder, he should be given the market and not me. But, my lord, the honorable court, my lord, lost sight of the fact that there was a clause which is the distinguishing factor in the earlier decisions and the present tender process, clause 10, which, my lord, gives the panchayat a direction to ask for the documents. Because, my lord, I quoted around 1 crore 61 lakhs, he quotes around 1 crore 40 lakhs.
Okay.
It is under that circumstances, my lord, the order was passed. Now the interference has been made. The last date operation is 30th, my lord. That is why I am before your lordship.
Operation 30th. For
30th
what?
of June.
Awarding the work.
No, the whole tender is till 30th of June, my lord.
Only.
Only, my lord.
The term tenure will
finish
end.
at 30th. my lord.
All right, we'll grant you 10 days imprimatur. What else? What do you say, Mr. Manta? Let him finish the tenure.
Only 4 market days, my lord. Only 4 market days.
Market days, my lord.
My lord, I am running the market, my lord. No, my lord.
You are running the market or he is?
No, my lord, I am running the market.
No, there was a status quo order, my lord, earlier.
I am running.
Now the matter, my lord, with the
So all right, now we'll.
direction is that he should be allowed to run. The interim order
Should be allowed to run.
should be allowed to run.
That's an interim order.
There is an interim order, 101, my lord. Page 101.
Already we have taken, man. Only
In
4
terms of
market
that
days,
order,
only
they
like-
have taken over.
I have deposited 1 crore 20 lakhs of rupees, my lord. Entire amount. I
We'll
have-
get that amount back, don't worry.
No, my lord, already.
What is, Mr. Nair, for how long did your client run the market?
My lord, the market was run by me from, my lord, from, I think, my lord, July to
Only for 2 months.
2 months, my lord, around that.
Only 2 months. Since then he is running.
No, more
From
than that.
before he is running
Before
and thereafter he is running.
Then all right, let him complete the
Only
tenure.
4 days.
My lord, no, my lord, only 4 days is left. And, my lord, I have already deposited, I'm the highest bidder, my lord. I've already deposited.
Maybe now it's too late in the day.
No, my lord,
But here
still,
for
my lord,
4 days.
4 days, my lord, is a bit around 1,37,000 per day, my lord. I am offering.
Then we'll have to take the view of the panchayat.
The panchayat, my lord,
One thing, my lord,
Panchayat-
something he says, then
my lord will have the order dated at page 93, my lord.
Yes.
That's the order with after his writ petition, my lord.
Hmm.
My lord would have the 4th paragraph from bottom, my lord.
Hmm.
Based on the facts of the case, it is observed that the chief executive officer Nagaon so-and-so violated the clause so-and-so and so-and-so, and also by not obtaining government prior approval under so-and-so. In view of the above, Panchayat and Rural Development has decided that status quo be maintained in Balisatra bi-weekly market in conformity with the orders passed by the department on 7/2/23. With this, it disposed of. Then the honorable court, my lord would have the paragraph at page 100, my lord.
Hmm. Yes.
The matter about the highest bidder in the settlement process under Assam Panchayat as amended is well settled by a curtain of decisions of this court. In the writ petition number so-and-so, in its judgment, it has been observed that as under process in the context of so-and-so encompasses within effect amongst other preparation of a comparative evaluation and so-and-so. 163 provides for examination tender by a general staff. The highest tender after examining in a given case may be rejected. Once rejected, such tender cannot come into consideration for the purpose of acceptance of settlement. If the words highest bidder occurring in rule so-and-so of the rules is given a literal meaning, examination evaluation as contemplated would be rendered meaningless. So it holds, my lord, that the tender of the highest bidder would mean the highest valid.
Run the market for 2 days each. Mr. Nair, we'll find out a middle way.
Lordship.
Both of you run the market for 2 days each. What do you say, Mr. Manta?
Lordship.
My lord, I have already deposited 1 crore 2
Let
lakhs.
him have it, my lord,
My lord,
immediately.
yeah.
Let me have
One
the
thing-
last 2
my lord,
days. my
One
lord.
thing I'm pointing out, my lord, your lordship kindly see, there is one, my lord, your lordship kindly see, he said.
Where is the clause 10 then? All right.
Lordship,
Let us see the clause 10.
Lordship.
Lordship.
Whether his bid was not the
43,
valid bid.
43, my lord.
Then all right, make us comment on the validity on the
Lordship.
basis of clause 10.
This has been wrongly, my lord, done, but anyway, they have translated it wrongly.
Hmm.
I have the vernacular at page 45.
Yes.
the highest offered rate of the tender in respect of all settlements of so and so will be considered for settlement. If any highest bidder did not affix their relevant papers, excluding
So
court
these
fee and-
two things have to accompany the bid.
It was there.
Documents can be filed later.
Then he should be, it should be, my lord, he should be allowed 3 days time to submit.
Yes.
If the bidder could not submit the same within 3 days, then his bid would be cancelled. So that there is something. When they offered that to me, my lord, I immediately did it. The money was also deposited. My lord.
No, my lord. Your lordship kindly see, he was issued the notice to him, my lord.
That I did not receive, my lord. First
My lord,
notice.
that is an incorrect statement. My lord. Page
But
57.
subsequently he has again been given that
No, my lord,
opportunity.
your lordship kindly earlier that, my lord, your lordship kindly see as
Page?
per the page 56 is the notice issued to him, my lord.
Just let's see.
Page 56, my lord.
Not receiving Mr. Nair
My lord, he
is
receiving,
again
my lord. Page 57 he
So
receiving.
that is been recorded by the
Record-
honorable
your
single
lordship
judge in
kindly
the
page
impugned order
57.
also, my lord.
that this notice was not
Not
received.
received, my
No, my
submission
lord,
is
page-
recorded. my lord.
Page 57 correct, my lord. Your lordship, his signature is there. Page 57.
Oh.
57 is different, my lord.
No, this is a copy in the vernacular
Yes.
of the notice. You have received this notice, sir.
No, my lord, this is a notice for deposit of the amount.
No.
My lord will see.
No, my
One,
document.
Documents, Mr.
Document.
Nair,
Photocopy of the passport size photocopy that is.
passport size photocopy, certificate of
Certificate, tax.
my
land
lord, this
documents.
is written OC Devnath Das. But my
Devnath Das.
instruction, my lord will have the order, my lord, that is the submission.
What will it take, my lord?
My lord will have page 99.
Explain how your signatures are there.
Mr. Nair, what happened yesterday? The matter was there on 12/6.
My lord, it was there, it was bottom, my lord. By the time the matter could reach, the time was over. My lord, I was also.
Because you filed the appeal on 13/6.
13/6. It was mentioned, my lord, but that day it could not be moved, my lord. My lord, page 99, para 6, my lord.
Both the
It is
signatures-
submitted by Mr. B.C. Das, Nanad Senior Counsel for the respondent number 6, that the respondent number 6 did not receive the offer letter dated so and so.
No, this is incorrect, sir.
But
How your
yeah,
signatures are there?
If my lord can have it after 2 minutes, I'll just have that instruction.
My lord, your
I'll have
lordship
that
kindly
instruction.
see in the other page, their signature same, my lord.
Also, also. Notice, sir.
Signature है क्या, sir?
Oh, my lord, my instruction is that this signature was purportedly forged. My friend was there, my lord, and there is a criminal case pending, no? FIR.
My lord,
Then let the FIR reach to its logical conclusion. No. We'll not accept this. Then.
That's what because my friend was there in the.
We'll compare it right now. We'll close the FIR also. No, follow it. Show us your wakalatnama.
Wakalatnama would be there.
Let's see.
my lord, in fact, next page which he received, my lord, he admitted that signature is same, my lord.
That's what
Maybe,
we-
my lord, if that is being so, my lord, I have nothing to say, my lord.
Page 59.
Yes.
No. No, my
Mr.
lord,
Nair.
both the signatures are not same. my lord.
Absolutely same.
57 and 59, my lord. would
No,
say.
no, read, check your wakalatnama. Take this.
No, 59 I received, my lord.
Read check your wakalatnama and the document. It's more than enough. The strokes, the curvature, everything is same. Don't ask us to close your FIR right now.
My lord,
At least the lawyers.
This signature matches with page 59, my lord.
57.
57, my lord.
Yes.
Subject to what my lord would
Look
say.
at D. Look at how the D is formed.
The D, my lord, matches 59, my lord. Both the D matches.
Very
59.
similar. All right, then we'll pass an order. Then let's wait for the outcome of the FIR.
My lord will not. If there is a doubt, my lord, I have nothing to say. If that is,
Obviously,
that's
the signature
my
is
lord,
there.
dismiss my notice.
It's okay.
Dismiss my.
So, yes. What's the stand of the department?
Lordship may kindly come to page number 84, my lord. In the meantime, the read appellant, my lord, he has preferred an appeal before the authority, my lord, before the principal secretary, my lord. And principal secretary has passed the page number 84 by granting the benefits to read appellant, my lord. Thereafter, the private respondent, my lord, in the read appeal has preferred the page number 85, my lord, and next 14.
That was interfered with. Then the hearing was.
Page number 85, my lord.
Now the respondent is running the market
Yes.
on the strength of the order of this court.
My lord, my lord.
And
The
express His argument is based only on the fact he submits the documents on the second notice.
Not
First notice, there's a denial, but which apparently does not stand at all.
Yes.
This is a signature
The
of this man.
subject matter of the writ petition is the page number 93, my lord. That was passed by the principal secretary after hearing both the parties, my lord. And as the difference is 20 lakhs, my lord, principal secretary has issued in favor of the.
But that can't be done. He has not filed the documents pursuant to the first notice
My lord.
under clause 10.
That-
Then he can't be given any more opportunities there.
If the first notice is received, then that's the end of the matter.
Is there
Yeah,
apparent?
That's it.
All right. Dismissed. Having heard and considered the submissions advanced at par, we find that and the appellant herein received the first notice under section clause 10 of the
NIT.
NIT, but did not submit the documents within the stipulated period of 3 days. Subsequently, a plea was taken that the first notice dated 27th June 2022 was not received by the appellant. However, after going through the photostat copy of the original notice placed on record at page 50 as annexure 3, we find that the appellant herein has definitely marked his signatures in endorsement of having received the notice. First up, at this stage, a plea was set up before the court that an FIR has been filed alleging that this signature has been forged on the notice. However, we would refrain from making any comments on the genuineness of the signatures as appearing on the notice because MFSI, on a comparison of the signatures appended on this document and the Wakalatnama filed on behalf of the appellant, we find stark similarities therein. Thus, there is no merit in this appeal, which is rejected.
The FIR is also gone.
Apparently 59 the signatures are different. 59 the signatures are different, Mr. Nayan. 57 and Wakalatnama are same.
Highly obliged, my lord.
One lawyer's fee is gone. Unfortunately. Sorry. There is-
Pass over meter 10.
Actually, we have received telephonic instruction from the appellant. We are no more pressing the appeal. Lordship.
And counsel for the appellant submits that he has received in instruction not to press the writ appeal, hence, deadlock pre-application seeking condonation of delay as well as the corrected writ appeal within packet file number so and so are disposed of as withdrawn. Whether now you do the final disposal, I am not doing it.
Daily list, item 41.
In this case, I have to file one additional affidavit indicating that what is the communication between the government and the APSC and what prompted the government to go for this board.
Okay.
Lordship, we requested for the file where the communications between APSC and the department was going on regarding the selection. That was submitted to in a case before this honorable court, not before this honorable, in one of the learned single judges court. It was submitted in the month of August last year. The file has not come out to us till now. These two documents which I'll not.
He'll not name.
That second last paragraph of the letter. It is also to be said a file number so and so containing documents relating to draft advertisement and the correspondence with APSC was submitted to your end on 23rd August 2022 in connection so and so. Link with the file so and so.
Order to pass police के रूल पर है ना।
So I need some time so that either lordship allows us to take the file and file the affidavit and
You,
again return
you
it back.
request the court concern to return the file,
Yes, that will be sufficient, lordship.
Mr. Saikia, Learned Advocate General, Mr. Saikia submits that the original file of communications on the basis whereof, the affidavit was to be furnished, has been submitted to the court during the course of hearing of WPC number 2089/2020. He craves liberty to request the honorable court for returning the original record so that court concerned, so that the affidavit can be filed on the basis thereof. Time period for is allowed. List on.
My lord, only thing is there was no stay regarding the advertisements. Proceedings are going on. Put it on 26. You can let us take a.
I have
chance,
no
my lord.
objection,
Yes.
but what will finally come out from that file, lordship? In
Let's see.
2017, we made a request to APSC to conduct the recruitment for this additional.
Today we
principal.
saw that fate of the APSC, we have issued notice in a PIL.
And after
What has
till
happened?
3 years, they could not start the proceedings.
No, because there was a stay order, my lord.
No, 3
Yes,
years.
this is the order.
Surely
stay
that-
order.
For 3 years.
No, my lord, in
APSC
WPC number 60005/21, there was a stay order.
All right, we'll take it
There's
upon
nothing, there is no other reason.
26 June.
Will,
Yeah. এইটোত মানসে stay দি দিছে।
একটু বেলেগ এটা বস্তু।
অ, 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 অ।
বৰ্ডখন কিয় বনাই? 3 বছৰ আগতে পেলাই দিছে। আমাৰ request।
মানসে advertisement stay দিছে।
Deeply obliged, lordship.
Item number 42.
May I please, Lordship, my lord?
Yes.
On last occasion, my lord, almost, my lord, we come to a court question, my lord, whether, my lord, deniable selection for SCR of 2015 should be considered or not, my lord. On last occasion, my lord, the court question, my lord, comes to the point, my lord, whether, my lord, deniable selection for 2015, so far as SCR is concerned, that has to be considered or not, my lord. So far as, my lord, SCR of 13-14, my lord, we considered that, my lord, to be fair enough, my lord. And now, my lord, only thing, my lord, since 13-14, no accepting or reviewing authority was done. So, my lord, so far as 15 is, my lord, that has been complied with as per the rule, my lord. So, my lord, at best, my lord, I can pray before your lordship, my lord, 2015 may be considered. That will, my lord.
Here I couldn't get what he's trying to say. You want to make entire submissions afresh. We don't recollect what was argued on the other day.
In fact, my lord was directed me to obtain instruction regarding the person earlier IF who was the reviewing authority. Now he is posted in the Karimganj, my lord.
Okay. Then
To make it review.
he can still review.
Yes, my lord.
So
That
then
is why
get,
my
get
lord-
that done.
Yes, my lord.
We'll direct that the ACR reviewing authority will complete the process.
My lord.
For which year? 2013-14.
My lord, as my lord, as per instruction from my client, my lord, SCR of 2016 and 17 has been already done, my lord.
Already done.
Only done. I have a copy of, a Xerox copy of with me, my lord. So, my lord, they can go with 15, 16, 17 as per rule.
What do you say? 3 SCRs are not available now available for the subsequent years.
Yes, my lord.
Earlier, my lord, the selection was conducted in the year 2016, my lord. That is why 13, 14 and 15 ACR was.
Yeah, those subsequent SCRs can't be considered
Exactly, my lord.
for the selection which took place earlier. Then only on you want that only on basis of 2015 SCR.
15, since my lord, one of the office memorandum, my lord, that has been given to me, my lord, by the petitioner, my lord. That said, my lord, earlier office memorandum was my lord, modified with ACR of two year only, my lord. Earlier it was 3 years, now it was 2 years only.
When did that modification come in?
That was, my lord, dated 7/1/2019, my lord.
So again, that is subsequent.
Yes, my lord. Yes, yes.
So whatever rules were applicable at the time when the exercise was undertaken, only those rules will apply.
Yes, my lord.
So we first get the ACRs review.
Yes, my lord. For 13, 14 and 15, my lord.
Mr. Katniar submits that.
Lordship, I have, may I submit Lordship?
Mhm.
Lordship for 13 and 14, the whole ACRs should be set aside, Lordship, because the reporting authority who was not the competent to write the ACRs because she was not the holding charge at the relevant
And that is another argument which you have to take into consideration then.
That was the whole issue before the Lanis single judge law.
The single judge has not set aside those FIR, those ACRs.
Lanis single judge had directed to
Let's see the order.
yes, Lordship. Order for de novo selection.
De novo selection.
Yes.
You let the de novo selections take place. What is wrong? Now you have 3 years ACRs.
So far as my lord, as per
Of course, the employees are not at fault because ultimately it's these reviewing and reporting authorities who are to blame.
my lord, to my limited knowledge, my lord,
Hmm.
as per the provision of the rule, in case my lord, if my lord, accepting authority or my lord, reporting authority or my lord, reviewing authority not there, but seen the SCR, my lord, they can report.
Let them do the exercise. You are unnecessarily held up now.
My lord.
The things could have been completed. This order was given in 2018. By now, fresh selections could have been done.
Then, my lord, the fresh, my lord, procedure may be, will my lord resolve this issue, my lord?
They will take into consideration the fresh
Yes,
3 years exercise ACRs. What is wrong?
It will be better, my lord.
All right, dispose of the latest 3 years
My lord.
ACRs to be taken into consideration. Fresh exercise of selection to be undertaken.
My lord.
Okay. Dispose of this term.
In that case, my lord, other eligible candidates.
They will also be entitled to consider. Yes.
Yes.
Of all eligible. Definitely.